Good morning or good afternoon, wherever you are. Welcome to the MUSA's webinar. Today, we are here with Bermuda's Privacy Commissioner, Alexander White. He is also the host of the 45th Global Privacy Assembly. Thank you so much for being here today. I'll just do a quick introduction. Since January 2020, Alexander White has served as Bermuda's first privacy commissioner, establishing the office and building the foundations for a successful data protection environment in the country. He is a licensed attorney in Illinois and the District of Columbia, and served as the founding member of the International Association of Privacy Professionals Privacy Bar Section Advisory Board. He founded the IEPP State, Local, and Municipal Government Affinity Group and served on the U.S. Department of Homeland Security's Data Privacy and Integrity Advisory Committee, DPIAC, for a 3-year term. Prior to establishing the Office of Privacy Commissioner for Bermuda, Alex served as State Deputy Chief Privacy Officer for the U.S. state of South Carolina, developing a statewide privacy program from its earliest days for over 70 state agencies and entities operating in finance, healthcare, education, and higher education. Alexander, welcome to the MUSA webinar. Really appreciate you being here today.
Thanks so much, David. Happy to join you.
And I mean, the last time we met, I think you were in town for the IPP's Global Privacy event here in Washington, D.C. What were your takeaways or thoughts on that event, seeing as that was just a little over a month ago?
Yeah, that's such a wonderful event. I like to think of it as kind of the big tent event for the privacy community because it truly feels like everyone comes to that event nowadays. We get such an enormous crowd, and it's just very energizing having everyone in one place talking and caring about these issues. But what I've seen coming from that and other discussions that I've had is the critical role of multi-stakeholder initiatives in how we solve these issues. There's a lot of expectation at times that the rules simply get passed down by the regulator, and people say, here, just do this. And I like to joke that, I cannot just bring you stone tablets down from the mountain and say, here, just do this. It does not work like that for a variety of reasons. So we have to emphasize the fact that it takes a village. It takes us all working together in order to solve these issues. And so that's something that I think is continuing to emerge and continuing to gain steam throughout these global conversations.
Yeah, I mean, I recall that it was about 5,000 people that were in attendance. They had to get a larger venue, or they expanded the venue space, and it was packed. I'm from New York, and it was like Grand Central Station at 7:30 in the morning. It was that filled with people. And it's great to see the progress the IPP has made over the years from what used to be a very small, 100, 200,000 people event to now 5,000, 4,000, 6,000. I mean, it's something else. And I think, I don't know if you were in Brussels last year, but that was another event that was just packed. It was about 4,000 people at the Security Congress, and the Privacy Congress, and it was something else. I mean, I know they're having an AI event next week. I don't know if you're going to be able to attend that or not, but you were also at the Boston AI event last year, right? And what
Yes,
was
that's
there as a privacy commissioner attending the very first AI conference that the IPP was hosting?
Well, it was very energizing. I mean, you talk about the journey that the IAPP's been on over the last 20 years and the growth that it's had. And it felt kind of like the world was new again. We were able to say, okay, how should these issues work? Because so many of these AI issues are being tackled either for the first time or in a manner or at a scale that's brand new. And so there's this intense excitement to say, okay, we're building something here. We're creating something. And that was very interesting. Although with that said, I think one of the most important messages that came out of that event was the fact that the existing rules still apply. So whether that's privacy rules, competition, intellectual property, whatever the case may be, the rules still apply to AI.
Yeah, I think people forget that sometimes, and they're like, "Oh, you saw that with the fintech regulations, and fintech companies, and they're like, oh, Graham Leach Biley doesn't apply to us. We're just here in the Wild West." And I had an opportunity to talk about that when I was in Scotland for the conversational AI conference there, and people are like, "Oh, it's the Wild West right now," and I'm like, "No, we have the GDPR. We still have to comply with that. There's all sorts of Canada's PIPEDA. I think Bermuda has PIPA, right? And so all of these regulations still are in effect for AI, Gen AI products and services. And so, just in case some of our audience is not super familiar with PIPA, do you have any, maybe quick primer on, things companies should watch out for and think about if they're complying or if they're doing business in Bermuda?
Yes, so PIPA is the Personal Information Protection Act, and it's Bermuda's version of the GDPR, if you will, or the CCPA. And so it was passed in 2016, and I came on board in 2020 to set up the office for the first time. So Bermuda is such a wonderful place, though, because it's a crossroads of cultures. There's British influence, there's North American influence, there's Caribbean influence. So the interesting thing about it is that we try to take some of all of that in everything we do. So it's not just a copy and paste of the GDPR. And I think that's to its benefit. One, because it's a lot shorter, which is nice for everybody, I think. But also, there's some strong North American influence, especially Canadian principles-based influence in the law. And what that means is, from a practical perspective, there's not as much kind of nitty-gritty to-dos in the law, so much as there is the obligation on organizations to perform a risk analysis and implement controls that are appropriate to that risk. And that, of course, can be a double-edged sword, because a lot of times people would rather you say, just tell me what to do, just bring me those stone tablets and I'll do what you say. And so to say to them, well, no, you have to make a judgment call about what your risk looks like and what is proportionate to your risk. And so a lot of what we've been doing over the last few years is educating the community about those risks and harms and what sort of practices would be appropriate to mitigate those risks. So you asked about what do organizations need to know, is essentially our goal is to make PIPA interoperable with other laws around the world, whether that's the new US laws that we're seeing at the state level or whether that's the GDPR. It has the flexibility that an organization could adapt its program according to whatever those compliance requirements are. And if it can make the case that it's appropriate to the risk, then that's compliant with PIPA. And so this is an idea that I've been playing with for a while. We put it in our regulatory strategy. It's called the Mid-Atlantic privacy. And so we're trying to take this idea of what are the human rights-based privacy protections that we're seeing out of Europe, but also the kind of the innovation of North America and the ability to be flexible and to try new things, and how can we marry those together? And so that's what we do with our Mid-Atlantic privacy philosophy.
That's very helpful, I think, for people trying to understand PIPA. One question I had is there the same concept as under the GDPR, the Article 27 representative for companies that are maybe foreign to Bermuda, but doing business or providing services in Bermuda? Do you have a registration requirement or a registration requirement for controllers that are operating within Bermuda?
No, there's not a registration requirement either for from a controller perspective or a privacy officer perspective. One of the important aspects of PIPA is that it does not have the controller processor distinction. So it simply is a question of whether an organization has personal information or not, or uses personal information. But the scope of PIPA is not extraterritorial. So it applies to organizations that are in Bermuda. And what I tell them is to consider in relatively broadly. It could be legal establishment, it could be physical establishment, could even be doing business. But it's limited to if you are in Bermuda. So we don't run into those sorts of issues of needing to reach into other jurisdictions that require those types of representations.
And so another question I had would be for the basis for processing data. In US, it's kind of like you can collect it, and then if you sell it or share it, that's when you need to maybe see if a user wants to opt out of that. But collection is generally fine. You don't need cookies or cookie banners to accept collection. Now in Europe, it's kind of a different model. Before you collect, you need to get consent from the user, and then you have to have certain bases or exceptions under which you're collecting or processing the data. So where does PIPA sit? Is it more permission before you collect, or is it more the US model or other jurisdictions where you can collect, and then if you decide to do something with it, sell, share, advertising, that kind of thing, that's where, some of the consent and permissions kind of come in.
So as a general rule, it's closer to the European model. So PIPA uses what's called the legal conditions, and an organization has to identify a specific condition under which it's using personal information. So these conditions align pretty well to what you see out of the GDPR. So required for a contract or required for employment purposes or things like that. I think perhaps the most interesting distinction, especially from a privacy law nerd perspective like us, is that instead of the legitimate interest test that you use under the GDPR, PIPA has a reasonableness test. So would a reasonable person object under these circumstances, which shifts the analysis a little bit in I think important ways.
And so the other thing that's really interesting, and this is a favorite topic of mine, is privacy controls. And you mentioned, risk-based approach, but then having controls in place. And just for the audience that maybe doesn't appreciate this, and I'll give my spiel for a minute and then kind of get your insights on it. A lot of times people will set up a privacy policy and they're like, we're done. And it's like, hold on a minute. How do you know that internally you're actually doing what your external privacy policy is saying you're doing? Because the privacy policy or privacy notice is supposed to represent what you're letting users know, hey, this is how you handle your data. This is what we do with it. This is for how long we keep it. This is how you can access data subject rights, that kind of thing. But the hard part is making sure that all of your systems internally are honoring what you're saying on the privacy policy, whether you're deleting IP address after 30 days or not sharing with third parties, or maybe you are sharing with third parties. And a big part of that is having a good set of privacy controls or processes in place inside a company to make sure that you're following through on your external representations. In Bermuda, like how much focus as a regulator do you give to a company and how they are approaching controls versus just putting up a privacy notice? And what do you see typically when you're kind of working with companies or things that you wish they would do a little bit better?
Yeah, so what I wish they would do is to take your advice and not start with the privacy notice, because what you need to put in the privacy notice are the important details about how you operate. And so if you're starting by drafting a privacy notice and you haven't yet identified what your data map looks like, what your business practices look like, how can you possibly explain those things? Because you haven't even looked at those things yet. So it's putting the cart before the horse, to use several different analogies here. And so actually when we developed an awareness campaign to help organizations prepare, because again, PIPA was the first privacy law for Bermuda. So we developed a campaign called the Road to PIPA that breaks down the different aspects of a privacy program into weekly steps that they can take on, so it becomes a little bit more manageable. And in fact, what we did is we put notices towards the end of that campaign because we wanted people to go through the inventory and go through the risk assessment and go through the controls and map out your outsourcing and all of those things, because that has to inform the privacy notice.
That's 100% in agreement on that. And it's a great approach to think about, hey, look internally, don't start with your privacy policy and work backwards. That when you think about that, that's how a lot of companies unfortunately kind of take that task on. And especially with retention and data minimization. How does PIPA approach data minimization? We hear a lot about that. I think in a lot of the recent regs in the U.S., they're thinking about making data minimization a key aspect of the regulation. And how does PIPA kind of look at that and think about, what data minimization is and what companies should be doing when they're collecting data or maybe not using the data that they collected?
Yeah, PIPA has a set of what's called minimum requirements, and these are privacy principles that apply regardless of other circumstances. So regardless of whether there's some kind of exemption that could apply. A lot of organizations will seek to exercise an exemption, whether that's for regulatory purposes, national security purposes, whatever the case may be. But having these minimum requirements as our core privacy principles says, well, regardless, you still have to meet these standards. And one of those standards is the proportionality principle. So this idea that what you collect should be only what is necessary to accomplish a specified purpose. And then from an integrity perspective, that's another of the minimum requirements. The information has to be accurate, complete, and up to date for the purpose and not kept longer than necessary. And so that this is a core requirement of PIPA. But by the same token, we as the regulator cannot go and create a retention schedule for every possible instance for an organization. So the onus is still on the organization to do the analysis to say, okay, well, what are your legal reasons why you may or may not need to retain something? But it is a core requirement.
Yeah, I think like here in the US, we say, oh, for tax purposes, you might have to keep financial transaction data for 7 years, but you don't need to keep search history for 7 years. And so that's the kind of trade-off where you're like, well, unless you do that analysis and understand, sometimes companies will say, oh, we're just going to keep everything. And they're going to be like what I refer to as data hoarders. You see, they have the shows in the United States where people go into a house and it's just like old books and stuff like piled up to the roof. And if you visualize a data system or a data lake, or platform, sometimes the platforms are like that, where they're just keeping everything and there's no retention, no concept of, hey, this user hasn't interacted with us in 8 years. We need to get rid of their information, because there's the cybersecurity risk. And so, in the sense of if there's a data breach and you haven't, worked with the user or had anything to do with them for many years, their data is at risk unnecessarily. So how does PIPA work with cybersecurity regulations, or is that kind of tie between or appreciation that some of these data minimization things tie directly to cybersecurity concerns?
No, there are specific controls, specific requirements that organizations implement security controls. That's actually another one of the minimum requirements of PIPA, is that an organization assess the risk of harm to an individual based on what misuse of the information might be. So that means you have to consider the sensitivity of the information and consider the context that the information is stored in, and then implement appropriate security controls against misuse or inadvertent disclosure or what have you. And there's also a breach notification requirement. So if there is a data breach that is likely to adversely affect an individual, an organization has to notify our office, and then we can provide further instruction if needed.
Now, is there a threshold? I know when we sometimes you help clients with data breach situations, and it's like, well, if it's, in the US, there's certain thresholds. If it's 10, 50, 100, is there any kind of a threshold for number of people impacted by a breach before the reporting requirement kicks in, or is it just even one, even if one individual is impacted, that they need to report?
Yeah, it's the latter. So there's not a specified number threshold for data breach reporting, but I do want to emphasize that it's not every data breach, it's every data breach that is likely to result in an adverse effect to individuals. So there's that subsequent test that has to be completed before the breach notification is required.
I think some people watching this and in that situation will be so thankful when they hear your clarifying explanation, because I know that causes a lot of stress inside organizations. Like, what is the actual reporting requirement? So that's a great takeaway for our audience watching. So I'd like to turn to talking about the Global Privacy Assembly. And Bermuda was the host last year, and I was there, and it was a phenomenal event. And just if people aren't too familiar, I'll just read a little blurb from your site, actually, Commissioner White, about the GPA's history. And it says the assembly has been in existence for more than 4 decades. It first met in 1979 as the International Conference of Data Protection and Privacy Commissioners. In September 2020, Bermuda joined the GPA as an accredited member under the helm of Bermuda's Privacy Commissioner, Alexander White, with full voting rights on joint resolutions and and an equal voice to participate in working groups. Today, Commissioner White serves as a member of the GPA Executive Committee and chair of the reference panel. So, talk to us about that event. I thought it was phenomenal. It was such a great gathering of privacy minds and privacy, all sorts of, regulators, people who spend a lot of time explaining privacy to other people. And there were so many good events, and there was also the focus on the Caribbean and the Mid-Atlantic and what the privacy initiatives are there. And I thought that was very informative to people coming from other parts of the world, because a lot of times you just hear about Europe or Canada, and you say, hey, there's a lot of stuff going on here that you need to be aware of. And there's a lot of changes and things that companies in the Mid-Atlantic need to appreciate. So could you talk to that a little bit? And again, I can't say enough. It was such a great event. So
Well, thanks for saying that. Yeah, and I'm very lucky because doing events like that is Bermuda's bread and butter. And so I was able to go to a lot of community stakeholders like our tourism authority or the venue and kind of tell them, here's what I want to do. And they would say, oh, well, here's what you need to do. And so it was very helpful in that way and gave me the opportunity to focus a bit more on the program because I knew everybody would fall in love with Bermuda just if they had the chance to come. So I think that the message that we really wanted to get out of that hosting the event is that we live in a plural world. And so what you were saying about sometimes we only hear from certain regions, I think that's so true. And it also means that we're only hearing from certain legal backgrounds, cultural backgrounds, but even the size of the jurisdictions as well. I mean, we are a very small jurisdiction. The total population of Bermuda is about 60,000 people. And so we have to accept that privacy just cannot mean the same thing as it does in a larger city like DC or New York or London or wherever else in the world. It's much more likely that someone can just, their internal facial recognition inside their brain is more likely to identify someone as their cousin or their old friend. And so we have to recognize that as the fact, but we also have to recognize that when there is a harm, the harm can resonate even more because there's nowhere to go, and there's no escape from it, so to speak. So that's one thing we wanted to do when we had that panel for the Caribbean regulators. There are a lot of new regulatory offices like mine throughout the region in places like Jamaica and Barbados and the Bahamas, Cayman, and so we wanted to provide that perspective of what does it mean in these regions in terms of resources. So, typically, well, regulators are under-resourced no matter where they are, but especially in very small jurisdictions, the resource and the personnel question can be very challenging. But not only that, there can be different drivers as well. We talked about the fact that PIPA is not simply a cut and paste of the GDPR. But for some jurisdictions, they feel it is their best option to do a copy and paste of the GDPR because they want to be seen as adequate and to be seen as meeting those same types of standards. And they feel like the most certain way to do it is that. But then that adds an administrative burden that they have to try to take on, that they may or may not be able to do so successfully. And I was really proud that a lot of people came up to us after that particular panel and said, this really opened my eyes. I had no idea some of the issues that you were facing in small jurisdictions, even our colleagues in larger jurisdictions, who I should say are incredibly supportive and offer guidance and share resources with us all the time. So it's hardly an us versus them situation. But yeah, I was very proud of that, and this idea that what happens in one place radiates outwards into other places. That was our theme of the event, Ripples, Waves, and Currents. And very excited to highlight some special events. I was especially proud that we got to have a panel talking about indigenous perspectives, which I thought was so interesting. And I think that we're reaching the point with science and technology where the Western legal tradition is starting to fray a little bit. And I think genetic information is a really good example of that, because the tradition of individual ownership over personal information kind of falls apart conceptually when we talk about genetic information, because so much of what I have is exactly the same as a sibling or a parent. And so how do we balance these things in a community context? And some indigenous philosophies do that in very interesting ways. And also focusing on gender issues and other less represented groups. So very, very excited to have the opportunity to say, hey, here's what I think is important. Getting to design that agenda is a huge privilege.
Yeah, and I mean, it showed the care and the attention to the agenda, and I mean, there was a lot of great conversations, and then additionally, just the breakout meetings and the in the hallway kind of conversations. I think the Hamilton Princess was an excellent venue for the event, and beautiful to be right on the bay there, enjoying the great weather and everything Bermuda has to offer. I think one of the other panels that happened during that time, I think it was a Future Privacy Forum panel, was on scraping. And I think that was a topic that a lot of regulators were working on. And I know there was some a meeting with the IEWG, the International Enforcement Working Group of the Global Privacy Assembly. A lot of words there. But can you tell us a little bit more about what, because you're a part of that organization and you're one of their thought leaders, what that particular group does and how they operate, and what's the larger goal for international enforcement, and kind of getting together at meetings like the Global Privacy Assembly to kind of think through some of the issues they're working on.
Yeah, and so we had identified scraping as a topic of concern. That was how you and I met last year, was discussing that topic, and so wanted to have it on the agenda, and we organized that Future of Privacy Forum side event to talk about that, which is fantastic. And actually, because I was so busy with planning the event, I had not been directly involved with the working group. And so I was not aware that there was this initiative to have a joint statement on scraping. And it came out just a month or two before the conference. And so unfortunately, it was too late for us to incorporate that into the agenda itself. But we did have a lot of great discussions by the International Enforcement Working Group on sharing best practices. There was a capacity building session, as we call it, where the regulators could come together in a closed door session and talk about practicalities, about enforcement. How can we really do these things and do them in an effective way? I think in this particular session was talking about data breach notifications, which we've already talked about a little bit on this chat, so it's always a relevant topic. But the fact of the matter is that it's hard logistically for organizations to have to notify every regulator, but also for regulators to receive these different notifications. It's a logistical challenge, and so I think that one of the interesting ways that international cooperation can really show its value is, if we were to do things like standardize how that functions. What if it was the case that we could have a centralized data breach notification reporting system that then got distributed to the regulators? So, I think that there are opportunities there where, working together with our international colleagues, we can not only make regulation easier, but make compliance easier.
That's right. I mean, when you think about it, yeah, the data breach notification standards, even here in the United States, you have 50 states that you might have to report to. But imagine if you're a multinational corporation and you have a breach and, it's not just a particular state, it's multiple countries. And their different reporting requirements and how difficult that is to manage, or even finding local counsel in each jurisdiction that's competent to handle that. I know I used to have to work on those kind of issues, and it's tough, right, to know who to talk to and who to work with. And I mean, I guess one of the IEWG statement on scraping was I think it was about, yeah, that's right, about 2 months beforehand, and they had gotten together and come up with that. And we actually just had a talk. I was just on a panel yesterday with a few members of the IEWG to discuss their work and discuss some of the issues around collaborating. And I guess just to kind of, for the audience, for people that aren't familiar with it, did you want to mention like what this statement is and just generally like how that works in the signatories and that aspect of it?
Yeah, so again, I wasn't involved in the drafting of the statement, but I'm an admirer of the statement. And so when it came out, I thought, well, how can we get involved? But to explain what it is, what we're talking about, in this instance, the working group members came together to try to identify some joint guidance on web scraping and practices related to web scraping. So the statement lays out what some of the risks are, specifically in the social media context, which is very often, a publicly posted or publicly available stream of information. But then also, what can social media companies do to try to mitigate the harm that can come from ubiquitous web scraping, and what can individuals do to try to mitigate their own personal harm. And I love this sort of effort because many of the problems that we are facing are not problems in a individual jurisdiction. Issues of social media scraping are not solved at the national level. It needs to be a global conversation. But by the same token, we cannot have the individual jurisdictions creating their own sets of standards, and then organizations are trying to figure out. We're seeing this right now in instances where there's a patchwork, and it's extremely challenging for organizations. So the more that we as regulators can come together and try to provide consistency in the guidance, the better it makes compliance for organizations, but also, in my opinion, it's more likely to raise the minimum tide of best practices for an organization. Organizations are more likely to take something on if it's considered unanimous. And frankly, when I'm having conversations in the community here, I don't want them to think, it's just crazy Alex who's saying you have to do this. I want them to know, no, what I'm telling you is a best practice. You would hear the same thing from our colleagues in the UK or our colleagues in Canada or elsewhere. And so, like I said, I wasn't involved in the initial drafting of this, but I'm very proud of the work that they did. And so I wanted to share something with you, David, which is that I have in my hand right here a letter of endorsement for that letter on joint scraping from last year, in which our office officially recognizes it, endorses it, and adopts it as guidance in Bermuda as well. And all of that said, I have not signed the letter yet. And so I thought I would take the liberty of doing the actual signing here on our discussion today.
Commissioner White, that's phenomenal. Wow, we're greatly honored here at MUSA, and that's I think that's a MUSA first for webinars to have a privacy commissioner signing their agreement with the joint statement. That's great. Thank you. And can we see the final document here? Oh wait, it's kind of
there. You go.
There it is. All right, pretty good.
It's disappearing into my privacy screen, but we'll post a copy online so you can see yourself.
So that's breaking news that Bermuda is now a signatory to the joint statement on data scraping and the protection of privacy. I believe you would be the 15th jurisdiction that's signed on to that. So that's great news. So thank you for sharing that moment with us, Commissioner White. And hopefully you can save that pen for the Bermuda Historical Society so that they can, that's definitely a critical moment of privacy here. And just to, I was thinking about this as we were talking about it. We're so steeped in this, but just to help some of people in our audience and be watching this for the first time or not understand like some of the differences, or maybe you could maybe explain it, seeing as people are probably more interested in hearing about this from you. What is the difference between scraping and like search and search indexing and that kind of thing? Because I think people, when we talk about scraping, like they may think, oh, like the Cobalt screen scraping from 2000, the Y2K issue, where people didn't want to redo their Cobalt stuff. This kind of scraping is different, right? This is company like a third party you have no relationship with grabbing data from your website, packaging it and selling it elsewhere. Is that kind of your understanding of it?
Yeah, and to use a metaphor, one way I like to think about it, to use a nautical metaphor appropriate here for Bermuda, it's like the difference between going fishing with a net and trawling the bottom of the ocean. And so, in the one instance, yes, maybe you are, casting a wide net to try, but you're still trying to find something in particular. You have a set purpose that you have identified. And what you're doing is you're indexing, you're searching. Whereas scraping is really going in and just trawling and sucking up as much as you possibly can, and then seeing what might be valuable. And that's completely antithetical to not only Bermuda's privacy law, but others as well. Ours does specifically address publicly available information, and as a credit to its pragmatism, it says organizations can use publicly available information. But what they have to use it for is for a purpose in line with the purposes for which it was made public. So that sort of mass scraping, trawling the bottom of the ocean, that's the type of thing that it would be an overreach under PIPA's law.
And I mean that's a great analogy, because I think people, it's hard to appreciate the difference between, and I was trying to explain this yesterday in the call. There's a difference between helping somebody find something, and you look at a site and you say, okay, this site is great for people that want to see cat pictures. We're going to put this in our list of sites that if somebody types a search term cat pictures, it's going to return that in the search results set. Whereas scraping, they're taking all of that content, to your point, they're trawling the bottom, grabbing as much as possible, and then saying, hey, will somebody buy this? Or, hey, can we use this to execute a phishing attack or build a profile about somebody so we can take advantage of them for some financial fraud issue or something like that. And so that's why it's so different. And I really like your strong statement about how it's antithetical to privacy and what we think about in general, because really the end users don't have any knowledge of the third party. They don't have any ability to exercise their data subject rights. And there's no alignment with what the scrape data is, being used for after the fact. It could be used for almost anything. And I think that's a problem. I think courts here are struggling with that, because here in the US, it's like, oh, it's public data and it's public. That means that people could do whatever they want with it. Whereas in Europe and in other jurisdictions like Bermuda, it seems just because you make something public doesn't mean a third party can come along and take your information and do whatever they want with it. And I think that's such a crucial right or understanding that I think is great that that's being promulgated in Bermuda and other jurisdictions, and something we need to adopt a little bit more here in the U.S.
Yeah, we've been for the longest time, and I say we because I am a U.S. citizen, born and raised, but we in the U.S. have relied on security by obscurity, I think, in a lot of instances, because yes, it was a public document, perhaps, and I know from my time in state government, we ran into this all the time. Yes, it's a public document. Yes, perhaps anyone could request it or access it, but it's down in the basement on a piece of paper, and someone has to actually walk into the office and get it. Whereas now the reach of the information has dramatically shifted. So this idea of court records being open, or of anything that's yes, it should be public, it should be publicized, but we also need to think about what is the purpose we're actually trying to accomplish in making it public, and how can doing it this way ensure that we're accomplishing that.
So a lot of companies to that point now, some companies may not be aware of the scraping risk. Others are very knowledgeable about it. But I mean, like when you talk to companies, do you ever try to say, hey, you need to think about externally what information you're making available? Because there is this scraping risk that is really hard to stop in some instances. Like somebody said to me, well, the only way to 100% stop scraping is to shut down your website or your web property because it's a real cat and mouse game, and with more protections, more captchas, more other things, you just make the property or this website harder for an individual to use. And so at some point, it's the friction of use becomes so onerous that they're like, well, look, we have to shut it down to 100% stop scraping. So what is your approach or thinking on the scraping issue and that kind of balance between there's only so much a property or a site can do to kind of defend themselves against these kind of attacks, which are really abusive service attacks.
Yeah, I mean, to an extent, that's a fair point, and I can understand what they're trying to say because the internet was built to share information. The internet was not built to stop people from sharing information. It was built to make it happen. And so when people were trying to figure out how to make it all work, the concern was, how do we get the information from one place to another? How do we see what's happening in different places? Not how do we prevent people from seeing what's happening in different places? So to a certain extent, the fundamental architecture of the internet tends to make this a common risk. And so I can understand where they're coming from there. But the fact is, we don't live in the same world that we did 50 years ago when the internet was invented. And unless we're going to use some of the theories promoted by some like Tim Berners-Lee that we need to completely reinvent the internet itself, which is a fascinating concept. I'd be willing to talk more about it in the future. But the fact of the matter is that unless we're going to do that, then we have to deal with the situation we have right now, that there are risks. Anytime you're putting information out there, you have to understand what the risks are and how you've at least attempted to mitigate them.
Now, there's also this scraping that happens kind of behind a firewall or people taking advantage of APIs and cracking them and getting beyond the API keys and pulling all the data out. Or even, I think we've heard more recently, people taking Gen AI models and using, I guess, a scraping at the prompt and hitting the prompt with multiple queries and just taking that information out and then using it to build other models or other applications. And so where do you see with the Gen AI revolution and the need for data to train models? And sometimes you hear about what they call the data wall, which is, hey, we've gotten all the data we can possibly get to train the models, and it's not enough to get us to AGI or general intelligence, AGI. Sorry, I misspoke there. But the scraping issue is kind of on the forefront there, where a lot of the data that's used to train models comes from the common crawl and things that are just grabbing as much data as possible from all over the web and then packaging it and then using it to build training sets that are used to train models that we use today. So kind of what are your thoughts about that and kind of trying to navigate that issue?
Yeah, and I can understand, again, I can understand where they're coming from. It reminds me of decades ago when that was the prevailing philosophy for information management in general. The idea of we need to collect as much as we can, store it just in case it's useful. We don't necessarily know how we'll be able to compute in different ways, but let's get it just in case. We've got all this wonderful hard drive storage, so let's go ahead and collect it. And so for the last decade or so, that pendulum has finally started to swing back to, or it finally started to swing to not that taking that collect everything mindset. Let's be a little bit more intentional about what we're doing and what we're trying to accomplish. But because of the growth of artificial intelligence and the need for data to fund it, we're swinging back to that other direction. And I don't know that we can necessarily stop that pendulum from swinging, but what we do need to do is do a better job of understanding what's happening to the data. And so when people talk to me about hitting the data wall or about needing to collect more, what I always want to ask them is to say, well, can you explain what the data that you have is actually doing and how that is actually affecting the algorithm? Because we need to be more intentional about how we're thinking about that. And so I don't necessarily have the answers for that, and here's where, again, I feel that we need to have multi-stakeholder solutions to these problems. We need to come together and utilize forums like sandboxes, regulatory sandboxes, so that organizations can open up their books and open up their drives and talk to regulators and have honest conversations so that we can develop practical solutions that do the right thing while also meeting those business needs.
A lot of before this kind of flood of regs around AI, there was a lot of the privacy regs had automated decision making kind of clauses or saying, users can opt out of that. And, I think people ask me, well, what were you doing before the AI revolution? It's like, well, AI was there, automated decision making was there. It was just different. And so we had to approach a different way, and we had to do our, survey of laws, but focusing on those types of things. And it's just, where does PIPA come down on automated decision making? To help people out there? And is there any plans to kind of add or amend it to now deal with some of these issues that are coming up around, generative AI or just use of AI in general in Bermuda?
Yeah, so here in Bermuda, PIPA does not have the same prohibition on blanket prohibition on automated decision making that you see under the GDPR, for example. If from a practical perspective, we get to a similar place, though, because an organization that's using personal information to make an automated decision is still using personal information. They still need to provide transparency about what they're doing. The individual still has an opportunity to demand access or correction or even deletion. So the typical legal analysis, if you will, still applies even to automated decision making. And in my opinion, a lot of those automated decision making rules have limited use in any case, because if a human steps in and says, yeah, I agree with whatever the computer said, then that's the end of the analysis from a legal perspective. And so how useful is that really in terms of an additional protection? I think it's an open question. And so with that in mind, we have been watching the different AI regulations that we're seeing in other jurisdictions, particularly the EU, the UK, Canada, other places. And it seems to me that the trend is essentially, on the one hand, we have the EU style of let's define risk categories and put specific controls around those specific types of risk categories, versus perhaps the UK style, I'll call it, which is, well, let's establish the principles and then overlay those principles on our existing regulations. So we talked about transparency that has to happen already under PIPA. Well, are there special elements of transparency that need to happen when AI is being used? What sort of additional details would be appropriate for AI? So I'm more inclined to think of it in that way, because that principles-based approach, because I like to have that kind of regulatory flexibility and to give the community the opportunity to innovate. What we often say is that our guidance is illustrative, not exhaustive. So we try to give examples of things that we see as being in compliance, but recognize that there could be another way of doing things that's still in compliance. And so we keep that in mind whenever we're talking about how these principles should be applied.
Yeah, there's a lot of work that needs to be done, and yeah, that makes a lot of sense. I mean, you see companies that are struggling to even with their AI models or services to honor, say, access or deletion or correction. And I think I saw my LinkedIn feed, somebody says, "Hey, look at this statement about correction." And I think the model provider was like, "Sorry, we may not be able to honor correction at all if there's some wrong information about you. The model is too complex." And I think that's probably a truth. Probably is there isn't a good way to just go into the bird's nest of the model and pull out one twig and say, "Nope, sorry, that's wrong," and put in something else. Um, but at the same time, the GDPR says what it says, and it says you have to provide the ability to have correction or access or something else. And so, as a regulator, when you see that kind of stuff, how would you work with a company and say, "Look, we can't do correction. It's just it's tough," or something like that? Like, what would would you say, well, how are you mitigating that risk in other ways, or how are you working with users to explain that, or what would be a good approach for a company to take?
Yeah, so the start of the conversation would be that you need to find a way to make it work. Or if you cannot make it work, that has to be explained to the individual, like you were just saying. So the individual can make that informed choice of whether or not even involved with the process, or if they would like their data to be deleted before it is used. And so that should be the beginning of the conversation. But if and assuming that someone is acting in good faith, if they still say, "Look, it's technically infeasible or even impossible for us to do this," that's where we turn to mechanisms like the regulatory sandbox. And so we've developed a confidentiality agreement that our office would enter into, so that organizations would not need to worry about sharing any proprietary information. And that way we can get down into the brass tacks, if you will, and say, okay, if it's not possible to do it, show me where the impossible part starts, show me where that is. And so that way we can consider what potential solutions there might be. And again, this is how I believe regulators should engage. It drives me crazy when regulators want to sit back and wait on someone to make a mistake. And thankfully, I think that's becoming less and less common in the regulatory community. But I think the only way we're really going to solve these issues is if we all get together and talk about how we can do it in the right way.
I think that's right. Look, for example, the IEWG's joint statement that you just signed is a prime example of that, where and the collaboration between the IEWG and yourself and ourselves, trying to understand the issues around scraping and help companies navigate that. I guess in our last few minutes here, be great to get some of your insights. The Global Privacy Assembly is meeting in in Jersey this year, their 46th meeting. And I was just wondering, do you have any insights or things you think that they'll be talking about in the coming year? And then just generally, what do you think we're going to see in the next year on privacy, cybersecurity, and AI from your perspective?
Yeah, so I encourage anybody who's interested to check out the Jersey's website, gpajersey.com, to follow along and register to attend if you're interested. And for the Americans listening, to emphasize that this is Old Jersey. This is the Channel Island of Jersey, and that's hosting the event this year. But I think it's really exciting, and I don't want to steal their thunder because the agenda has not come out yet, I don't believe. But it looks like there are going to be some really exciting speakers talking about not only how we protect information, but how we use information. And I think that's such an important point. This is not simply a matter of preventing the use of data, preventing the use of information. There's a lot of positive good that can come from using information. So that's a really important theme that I see coming out of this. And I look forward to being there myself. It's a great opportunity to see so many regulators all in one place. But in general, in the next year, one of the things I'm really curious to keep an eye on as well are the use of AI assistants. I think that's a really interesting phenomenon that the time may finally be ripe to see that actually start to come into play. And I'm really curious to see how that will be incorporated into our daily lives. And also from a privacy perspective, I think that could be an amazing tool to help us manage all of the different technologies that we use in our lives. If I could explain to I almost said convince, but if I could explain to my AI assistant what I want my privacy settings to be, then they could go and tick all of the boxes for me, so I don't have to do any of those cookie pop-ups, for example.
That would be a huge win. I know when I was at the European AI Chatbot Conference, they talked about using AI assistants in the customer service area where a customer service rep may get 100 emails, and some of them are very angry. You didn't send me my package. You're terrible. I hope your cat dies, that kind of stuff. And instead, removing the invective and that language is saying this user needs a new package, this user needs to make that experience. And they had one company that had actually done some testing and found that it was so much more, the people were more productive because they weren't being emotionally assaulted as they were reading these angry letters from unhappy customers. They were just able to focus on, okay, they need A, B, C, D. And so you're right about the potential for some of these AI assistants to kind of take away some of the, kind of maybe make things more neutral, assist us in different ways, parsing through thousands of emails we get every day or every week to kind of figure out what do we really need to focus on. And I agree, it's a huge potential. So that'd be great to hear about that in the coming year. Is there any things in Bermuda we should be aware of? I know you had mentioned a privacy conference or trying to put one together for the Mid-Atlantic. Is there any progress on that or anything we can look forward to?
Oh, I don't go volunteering me for another conference, David. I think my staff will kill me if I volunteer for another event. But in all seriousness, we have had some great conversations with our greater Caribbean community. We have regular engagements, and there are a lot of new offices, so we have a lot of things in common. And I do hope that we could host a get together with that group. But for the time being, we're focused on supporting the community with complying with PIPA and making sure we can make that as smooth a process as possible.
Well, Commissioner White, thank you so much for a great hour of insights and always amazing to talk with you. And I really appreciate the time. If people want to continue the conversation or follow up with questions, where can they find you online?
Well, I'm on LinkedIn. If anyone wants to follow me there, feel free. But our website for our office is privacy.bm. So that's the Bermuda country code, privacy.bm. And you can find all of our guidance and resources and the road to PIPA and my Mid-Atlantic privacy compass. If you want to hear more, that you can read to your heart's content.
Great. Thank you so much. And thank you all for attending our webinar today. Really appreciate it. Take care.
Cheers. Thanks, David.